Good morning. The Erie Doctrine, just the rules. The Erie Doctrine applies to diversity cases only. The rule, when a federal court is sitting in diversity, it applies the substantive law of the state in which it sits, including its choice of law rules, and federal procedure. And that is from Erie and, of course, Claxon. Now, what is the purpose of this? What it really means is that when a federal court is sitting in diversity, its decision on the merits should be the same as the one that would be reached by any state court. So let's repeat that. When a federal court sits in what? That's right, diversity. Its decision on merits should be the same as one that would be, reached by a state court. When a federal court sits in diversity, what happens? Its decision on the merits should be what? That's right, the same as the one that would be reached by a correct state court. The rule is, repeat it. That's right, when a federal court is sitting in diversity, it applies the substantive law of the state in which it sits, including its choice of law rules and federal procedure. And that's Erie and Claxon. But what it really means is, tell me, when we have a federal court sitting in diversity, its decision on the merits should be the same as the one that would be reached by a state court. So the Erie Doctrine, don't get confused, it applies to diversity only. What rules will always govern in federal court? Correct. The procedural rules, the federal rules of civil procedure are procedural. They will always govern in federal court. So, state substantive law. When the federal court is sitting in diversity, it applies the state substantive law, so its decision on the merits should be the same as the one that would be reached by a state court. So, the state substantive law will be applied if there is 1, no valid and controlling federal law, 2, constitutional issue, or 3, treaty. When are we always going to get state substantive law? If there is no what? That's right, valid and controlling federal statute, 2, that's right, constitutional issue, or 3, treaty. Let's repeat that again. When will we always get state substantive law? 1, no valid and controlling federal statute. 2, or constitutional issue, or federal treaty. All of those things will be supreme over state substantive law under which clause? Oh yes, the supremacy clause. Now, what about if we can't decide whether an issue is substantive or procedural? That is when we apply the what? Modified outcome determinative test. This is a mouthful, but it is easy. We ask ourselves, would applying the state or the federal law determine the outcome? If the answer to that question is no, what law will we apply? The state law or the federal law if there's no 1, valid or controlling federal statute, constitutional issue, or treaty. But if we don't know, would the law be outcome determinative? Would it affect the outcome, the ultimate outcome? If the answer to that question is no, easy. But what if the answer to that question is yes? We will balance the federal and state interests to determine which law to apply. That is the outcome determinative test. It is so easy. All you do is balance which interests? That's right, federal and state. Why would we apply state law? When would the state have a strong interest? Well, one, under choice of law principles, a state could designate an issue as arguably substantive or arguably procedural. Just look at choice of law. But one other reason a state would have an interest is the very obvious, to discourage what? Forum shopping, and thus avoid, that's right, the inequitable administration of justice. So when does the state have a strong interest? One, when we have a choice of law issue. Two, to discourage, that's right, forum shopping. And three, to avoid, that's right, inequitable administration of justice. When is the federal interest strong? When there's an issue that strongly relates to federal common law, such as foreign relations or currency. Okay, so remember, we apply state substantive law if what? There is no valid controlling federal statute, constitutional law, or treaty. What's always a controlling federal statute? Everything that's reserved to the courts, such as bankruptcy, such as taxation, all of that is under federal law. If it's a constitutional issue, such as someone's substantive rights, or if it's a treaty with a foreign nation. Otherwise, we're going to get what substantive law? That's right, state. And if we can't decide, we are going to use the, that's right, modified outcome determinative test, which is a what? Balancing test. We're going to balance the federal interest and the state interest to determine which law to apply. We apply state law to discourage forum shopping and to avoid, that's right, inequitable administration of justice. Sometimes there is a strong federal interest, such as foreign relations or currency, and I'm sure there are other examples which I can't think of right now. We would then apply federal common law. Why federal common law? Because there's no valid and controlling federal statute, constitutional issue, or treaty. Before we wrap up, let's repeat the rule. When a federal court is sitting in diversity, it applies the substantive law of the state in which it sits, including its choice of law rules and federal procedure. Why? Because its decision on the merits should be the same as the one that would be reached by a state court. And that, my friends, is the Erie Doctrine.